You betrayed your city. You caused your lovely wife heartache.
The courtroom can be a harsh reality check for police officers where karma hits in ways they never see coming. Today, we're looking at cases where ignorant and reckless cops pushed too far and were destroyed in court.
On January 28, 2015, a 58-year-old man by the name of Floyd Dent was driving around when he was stopped by Officer Melendez for a minor traffic offense. However, the actions that Melendez chose to take from there end with him being punished.
January 28, 2015, where his life changed forever. He was stopped by the defendant, a then Inkster police officer, and his partner, Officer Zelenuski. Mr. Dent was stopped for a minor traffic offense and ordered out of his vehicle. With his hands extended out of his driver's window, he was grabbed out, thrown to the ground, and struck 16 times in the head by the defendant.
These types of scum are what defame our police force. They exercise their force illegally on the very people they're supposed to protect and then act a victim. Pathetic.
The responding police officers arrived as the defendant is wrestling the defendant to the ground. Mr. Dent was struck, kicked, and tased while on the ground by what appeared to be a group of angry, anxious police officers that celebrated after the defendant was beaten and cuffed.
I don't get how such police officers even live with themselves. These cops are indicative of deep-rooted problems in our police force that need to be handled immediately and by force.
But the one image that struck out to the court was looking at Mr. Dent in his cell, shaking his head in disbelief of what had occurred to him. If his conduct was indicative of what he was thinking, I would have thought this: what crime did I commit? Being a black man in a Cadillac, stopped for a minor traffic offense by a group of racist police officers looking to do an...
Well, Melendez is one of the stupidest officers I've ever seen. How do you commit such an act on camera and expect to get away with it? He's done himself for life. He'll never be seen the same way again.
The purpose of it was to harass and degrade a motorist in Inkster. The man chosen for your game was Floyd Dent, a black man. The game went like this. Let's follow a car in a known drug area, and based on your years of training experience, you knew that the motorist would likely be a black person, no license, armed with a vehicle. Took me several days to read the letters that people sent talking about your character, about the man that you are, about how you went in Westland and helped to save 3 senior citizens from a burning building. 3 of those letters, I believe, were from African Americans, and 1 even professed to be like a mother. 1 or 2 things: either they're all racist, or there's something redeeming about you that somehow in some way you forgot that night.
The age-old trick of fake letter. Does Melendez take this judge for a fool? He's just digging himself into a hole here, and I'm loving it.
At the station, the other eye of justice captured you and your posse making fun of Mr. Dent, mimicking him struggling while you all wiped the blood off your uniforms with disinfectant while he watched. Such an awesome, caring, properly trained police officer. You led your fellow officers down a path of cowardly behavior. You betrayed your city. You caused your lovely wife harm. And you caused Mr. Dent severe anguish.
Tell him to make fun of Mr. Dent now. I bet he doesn't have the guts anymore, seeing as to how big of a pickle he's gotten himself in.
Today, I can only punish your conduct, but only you and God can change your character. I've had an opportunity to listen to both sides. And I had to say this because I didn't say this during the trial. But it was my privilege to be able to oversee this trial because I had great lawyers.
Look at his face. This man isn't guilty and emotionless because he feels bad for what he did to Mr. Dent. He just feels bad because he happened to get caught in the act.
I am going to commit you to the Michigan Department of Corrections. However, after weighing the allegations in this particular matter and looking at all the circumstances, including what you've done and who the person I really believe that you are, I'm going to commit you to the Michigan Department of Corrections as to count 1 for no less than 13 months, no more than 10 years. As to count 2, I'm going to give you 90 days credit for time served and close it out. The court's going to give you 85 days for credit. You have 42 days to appeal my decision. That concludes this matter. Thank you.
He should be glad he only got this much time. He deserves to be put behind bars for a long time.
I am truly sorry that you believe my actions were unjust. Please have faith in your law enforcement officers, for many of them would risk their life for yours.
Melendez even went as far as to claim that he suffered from PTSD. But honestly, I don't buy it, and neither did the judge, so Melendez's plea was not entertained. William Melendez apologized to Dent, the community, and his family shortly before he was sentenced Tuesday to 13 months to 10 years in prison. Like in this case with Officer Melendez being sentenced for his wrongdoing, this next officer also failed to get away with his crimes as his case came before a righteous and no-nonsense judge.
Cameron Lamb is dead. Eric DeValcanere killed him.
On December 3rd, 2019, Eric DeValcanere was alerted to a crime committed by Cameron Lamb. However, once he arrived at Cameron's property, everything seemed to go horribly wrong and he landed himself in court for his actions.
And the parties have a right to expect that no matter what I hear, I will only consider factors that are appropriate and that I will disregard those that are inappropriate. And that is what I've done here, and as a result, I've concluded as follows. There are a number of facts in this case that are both aggravating and mitigating, sometimes all at the same time. First and foremost is this undeniable and uncontested fact. Cameron Lamb is dead. And Eric DeValcanere killed him. That's undisputed.
I really like this judge. He's getting straight to the facts. No BS, no irrelevant information at all. This is how all judges should be.
Cameron Lamb's death leaves an irreparable and unfillable void in the lives of his family and his friends, and also in our community. Also, as I'm weighing all these facts, it can't be overlooked that the events of December 3rd of 2019 were initially set into motion by Cameron Lamb and his decision to chase his girlfriend through city streets at dangerously high speeds, putting motorists and other members of the public at risk.
I love the judge's objectivity. No bias, not that I can say that about many judges that I get to see on this channel.
Pulling up to defendant's house, Sergeant Schwam pulling into the driveway, immediately getting out with his weapon drawn, rapidly moving into the backyard, carport, garage area of the house, and defendant doing the same. Both without taking a breath, without pausing for the briefest of moments to consider where they were going, what they would find when they got back there, whether they were acting lawfully in doing so, and whether there might be some other safer option, without so much as a "Hey Troy, wait." At any point, Sergeant Schwam and the defendant could have done this.
These cops never think in the moment. They always end up regretting it when they end up in front of a judge. Sad truth is, their actions can't be taken back and their victims can't be brought back.
Eric DeValcanere is not Derek Chauvin, who murdered George Floyd. Eric DeValcanere is not one of the 3 men in Georgia convicted of running down and murdering Ahmaud Arbery. This is a mitigating factor. Defendant has no prior criminal history. His ORAS scores him as a low risk in all categories. Defendant's history as a police officer, husband and father, friend and colleague is also a mitigating factor that I have taken into account, as his father asked me to do, which I was already going to do, and that is to consider the totality of the circumstances.
This is how a professional judge is. Completely objective, takes all factors into account, and doesn't let emotion sway him. If we had more people like him in our judicial system, I'm sure it would be a lot better than it is right now.
Have demonstrated he has not hesitated to immediately take action when he believed the circumstances surrounding him warranted it. And this trait has generally served him and others well. It also failed him, as it did on December 3rd of 2019. All of which, however, leads the court back to where it began, an evaluation of the impact of the defendant's crime on Cameron Lamb and his family. Cameron Lamb is dead. Eric DeValconaire killed him. Having concluded, as I have, having considered all those factors, I ask counsel if there's any legal reason or cause having been shown why sentence and judgment of the court should not now be pronounced.
Not from the state, Your Honor.
No, sir.
Eric DeValconaire on count 1, the Class E felony of involuntary manslaughter in the second degree, I sentence you to a term of incarceration in the Missouri Division of Adult Institutions of 3 years. On the unclassified felony of armed criminal action, I sentence you to a term of incarceration of 6 years in the Missouri Department of Corrections.
DeValconaire was convicted of manslaughter and armed criminal action in 2019 killing Cameron Lamb and was sentenced to 6 years in prison.
While the first officer may have gotten off lightly, the next judge had no tolerance and completely tore into this tyrant cop.
Imposing further sanctions today.
On November 9, 2023, Jamie Null was arrested and had since been charged with 31 felonies. While Null seemed confident initially during the case, the judge's fierce attitude and demeanor quickly put off any sort of leverage he thought he could get.
Good afternoon, Your Honor.
Thank you very much. C01 2403 MC 634, that being in criminal contempt of Jamie Null, and 10 C01 2311 F5 297, that being State of Indiana versus Jamie Null. You may have a seat. Thank you. Mr. Bowles, it's my understanding you have the gentleman here that conducted the search of the Null properties.
I do, Your Honor. Let the record reflect that on April 17th, after our original contempt hearing, I requested this court to consider appointing an independent person to do a complete, thorough search of all 4 of the houses that Mr. Null had control over. The court accommodated us and issued that order.
The investigator who was hired was then brought to the stand to answer questions.
Well, let's start with the first property that you talked about, which would be 3001 Old Tay Bridge in Jeffersonville. Is that the residence?
Yes, sir.
Okay. Were you able to locate any weapons in that home?
I did.
And what did you locate?
I located a Glock 26 pistol, semi-automatic pistol, a Sig Sauer 1911 semi-automatic pistol, and a shotgun.
Okay, let's be very specific on the first, the Glock 26. Did you also take a photograph of where that was located?
I did.
Okay, could we have a picture up on the screen which would be for the purpose of having you identify the area where that weapon was found, is that correct?
Yes, sir.
And what room of the house is that?
That is a closet next to the laundry room. As you're looking at the photo, the laundry room is in the background of the photo, and the closet is the main part of the photo. Yes, sir.
Where was the gun located?
It was located...
Why don't you come off the stand if the court would permit and point to the photograph?
It was located in with all these items that are shoved into the closet area here.
Was it on the floor? Was it in an item, or where was it?
Actually, at the time that I located it, I was pulling items out of the closet, and there was a nylon zip case and I opened the nylon zip case to see what was in it, and that's when it was a gun box inside the zip case. I opened the gun box, and the gun and one magazine was in the box.
Was the weapon loaded or unloaded?
It was unloaded.
Can we show the second photograph, please? We're now showing a new photograph of a picture weapon. Can you describe that, please?
Yes, that's the Glock 26 pistol that I found, and that's the manner in which I found it. It was in the box, locked back, and the magazine was in the box also.
And that's the one that came from the closet?
Yes, sir.
Correct?
Yes, sir.
Okay. You can stand there because we're going to move to the next location. Did you also, as part of your search, in searching all of the house, went to the master bedroom?
I did.
Okay, and is that the photograph of a closet located in the master bedroom?
Yes, sir.
Okay, and was there a weapon located there?
There was.
And what was the weapon?
It was a 6-hour 1911 semi-automatic pistol.
Okay, and where was that weapon located?
It was located in this area of the floor. There was a pile of stuff.
You secured both these weapons, is that correct?
I did.
And you have them under lock and key now, is that correct?
Yes, sir.
Okay.
Assume that was a 45.
Yes, sir.
Judge, if we could have this marked and we'll offer that into evidence. And it's a photographs of all the pictures you took in all the properties.
Any objections, Mr. Herrera?
No, Your Honor.
How you marking it, Tom?
You want State's Exhibit 1?
I'm sorry,
State's Exhibit 1.
not state to do it.
I mean, Defendant's Exhibit 1.
So it's exhibit 1 and then
Right,
yeah.
I'm sorry.
We're always the blue state. Mr. Brown, I'm going to hand you what's been marked for identification as Defendant's Exhibit 1 and ask you, can you identify that?
Yes, sir.
What is that?
That's a thumb drive that contains the photographs that I took from examining all 4 properties and also photographs of all items that I located.
Now the lawyer of the defendant, Jamie Null, chose to ask the investigator some of his own questions.
The 2 guns that you found, the Glock and the SIG,
Yes, sir.
were you told where to look for those?
No, sir.
Nobody told you to look in the master bedroom closet or the laundry room closet?
No, sir.
Did you have any contact with the defendant, his wife, or his daughter?
With his daughter.
Which daughter?
I think Grace.
What was the extent of that contact?
Just to advise that I was at the home.
Had you ever met any of them before?
No, sir.
Had you ever met the defendant before?
I do not specifically recall ever meeting the defendant.
Do you recall off the top of your head what vehicles you searched?
There was a Trans Am and a BMW at the residence. Then there were several what I would call classic cars, older cars, at the pole barn at 709 Old Salem Road.
Several, more than 10, less than 10?
I would say 10 to 12.
Thank you, Mr. Brown. Nothing else.
Mr. Boyles, anything else?
I have no further questions. Thank you.
Mr. Brown, you retired in 2022.
Yes, sir.
Were you able to keep your service revolver or sidearm?
No, sir.
Do you have one you typically carry?
I do.
Do you know where it's at all times?
Yes, sir.
Did you always know where your service sidearm was? It's probably not a revolver, was it?
No, sir. Yes, sir, I did.
So to find a service revolver, I keep saying revolver, service firearm, in a duty belt with other mags, that's not too far-fetched to believe that one would know where that was at, would it? Rhetorical question, you don't have to answer.
Yes, sir.
Just reinforces my decision to impose sanctions. The Remington shotgun, was it in a box when you found it?
No, sir.
Was it near a box? A Remington firearm box?
Not that I recall.
Did it still have tags on it?
No, sir.
Where was it at?
I located it in the basement, what I generally term the theater room.
And not loaded?
No, sir.
Not much use for self-defense, is it?
No, sir.
If you were in the upper area and you needed a firearm for self-defense, where would you go of the ones you found?
The closest one would be the 6R1911.
The judge intervenes and showcases his firm attitude towards such cases, asking rhetorical questions to solidify his decision against former Sheriff Null in the case.
Mr. Boyles, I'm not going to impose any further sanctions today because it was not certified to me that there was no further firearms. But after today, if there's any further firearms found, there will be additional sanctions. So if your client needs to tell you something, he needs to tell you right now. You need to take a few moments and ask.
I'll be happy to, Your Honor.
Why don't we go off the record so he can speak with his client? I know you have a job to do on behalf of your client, but as I indicated, finding these additional weapons just reinforces my decision. And a matter of fact, I wish I'd have made it longer. So, but I'll stick with the 60. Thank you.
Thank you, Your Honor.
We'll be off record. I'm going to reiterate this again. I told Mr. Null not to do anything stupid, not to deceive me, not to defy me. He would not like the consequences. Didn't seem like you listened the first time. You released, and thus I sentence you to 60 days for contempt.
The judge, in this rehearing of the case, given a further discovery of Null's crimes, refuses to give him any forgiveness in light of his ignorance of the justice system.
You know, I'm just a country boy from Washington County with a public school education. But when somebody warns me not to do something, I try to heed that warning because we say what we mean up there. So this is my analysis. With the informations and the affidavits that were filed, it appears that you had, or at least did have, an airplane, a train that was hidden, a stable of exotic motor vehicles, a harem of women, at least 3 mansions, at least $3,000 suits, $800 belts, which you get personally delivered. And still seem to think that the Utica Volunteer Fire Department's your personal piggy bank. So with all these luxuries and all the money that you've allegedly taken, I'm thinking about $1.5 million in bond ought to be appropriate. should be able to post that with no problems with everything that you have. If you don't listen to that, and you post it, I don't know where we're going. That's
There's
it.
an increase by 1.5 million or the total 1.5?
Oh, do you have that much in the bank of Auditor over
I
there?
was just trying to figure out my math over here.
We'll make it 1.5 even.
Thank you.
Shall we hold him till you go get it?
I would say this is Wilder probably would have a question.
In April, Null was sentenced to 60 days in jail for violating the terms of his bond. In June, he was charged with 6 new felonies for a total of 31, and a judge raised his bond to $1.5 million.
Next, another tyrannical cop is taken down in court for harassing the auditor Sean, who decided to file a lawsuit against him.
Reyes circled around me and did not give me his name or accept the department card. As he headed up the stairwell, I thought in the best of City Hall, I keep him around and prevent him from going upstairs. He kept coming toe-to-toe with me. I extended my arms to prevent him from going to the second floor. Okay.
This is what it is.
If you want to, yeah. All right, do me a favor, we're not done yet. Sit. Where's the pen? You got your pen? Yeah. Okay. I'm going to submit a warrant. I'm going to review the camera footage, right?
Yeah.
I'm going to get his statement. I got his statement, your statement, and the camera footage.
Yeah.
I'm going to put that all in a report.
Yeah.
I'm going to review it.
Yeah.
If I have probable cause to believe that your actions
Yeah.
rose to the level of, I would call it an assault, since luckily he admitted to me that he was not injured and he did not want medical attention.
Yeah.
Although,
Injured, I mean,
an impairment of, injury,
Yeah.
According to definition, is impairment of physical condition. So I'm not going to do it to you.
Yeah, but I mean, I didn't
But if
try just like
I know it
hands,
doesn't matter. If you push somebody, I'm not going to do it to you because I don't want to assault you.
Yeah.
But if you impaired somebody's
Well, it's
physical
nothing like
condition.
that. I just kind of put my hands up.
Well, okay. So, however, if I think it rose to the level of a discon,
Yeah.
I'll submit warrants, maybe even for both of you. If some of his language is to the point where it's
Yeah.
disruptive,
Yeah.
then I'll submit a warrant for both of you, and we'll see and then it's up to
So
the
you told
court.
me I could get arrested?
Yes, it's up to the court. You got physical with somebody that, for the most part, you really had no reason to be physical with.
I didn't want him going. I
because he
wasn't
was
going
filming.
upstairs.
I know, but for
Yeah.
what? For what? He's filming. What is he doing? Why can't he go upstairs? It's a public building. It's City Hall, for Christ's sake.
Like I said, if I was given those forms,
You know?
Sean doesn't use any disruptive language and remains respectful. I'm sure you've seen us review multiple videos of his audits. The real deal is how physical the officer got.
After I had watched the library incident, I had seen on his channel that nearly every single one of those videos cast the police in a negative light. So I was fearful that regardless of what I did that day, right or wrong, the same would be done to me. Yes, that's exactly what happened.
Right. That didn't happen to you, right?
Oh, no, it did.
It did?
Yep.
Okay. And the incident at the library that you're talking about, the videos, you're talking about the videos involving, I think it's Tippett's and Utter, and the statement that if he'd done something 20 years ago, he would have been dead in the back of someone's trunk.
Objection is what?
20 years ago, that would be dead. His teeth would be missing.
I'd have removed his teeth. He would be dead.
This is not going to end well with you, you know that.
Okay, we'll see.
So the cop was worried that Sean's video would cast him in a bad light by referring to a library video where a cop gave him death threats.
Relevance, hearsay, outside the scope of arrest.
Sustain. Keep going.
Okay. The incident at the library, were you familiar with what happened there?
Objection, same, all 3 grounds.
Keep her out of that, Judge.
There's been some discussion in the trial thus far about the incident and how to ask this question.
And that involved Danbury Police Department, police officers, right?
The incident, I'm sorry.
At the library, sir.
Yes, it did.
And you're familiar with the library incident, right?
Yes.
And are you familiar that Mr. Reyes made a complaint about Danbury police officers in that case?
Objection, relevance.
I want to allow it as...
At the time of this,
Okay, here's how it's going to work. He's going to ask a question. He may object. I rule in the objection. You don't answer until I rule in the objection. Got it. It's going to be easier for everyone. And that's partially on me because I fall. So let's try that again. Ask the question again, answer, see.
These two incidents had totally different levels of intensity. The defense, in this case the state, was trying their best not to have the other Danbury officers be included in this hearing, because their statements were beyond inhumane. But the judge was annoyed by their interruptions.
At what point?
At any point.
I received a couple on my work voicemail, but I just didn't.
Did you put that in the police report somewhere?
Well, I was threatened after the fact.
Well, threats are important, aren't they?
It depends if you feel threatened or not, and I didn't feel threatened by them. I just deleted them. They were on my work voicemail.
So you didn't feel threatened about what people had said, correct?
Objection, pass the next one.
I'll allow him to answer his question. Objection overruled.
It's a tough thing. I can threaten you right now. It all depends how you feel about it. I would hope that, you wouldn't feel threatened by me, but so at the time, I just deleted those messages. I don't remember if I felt threatened or not, but I didn't want to. I just deleted it. It was only a couple. It wasn't like the other people, other officers.
This cop was just bluffing. Threats are no joke, and those threats could have been substantial evidence against Sean in this case, but they weren't real to begin with.
Approach. Off the record. Approach.
Mr. Reyes arrested, is that what you did?
I would object because that mischaracterizes the testimony. He said he had a question morning, not the afternoon.
Sustained. It does mischaracterize the testimony. Ask a question,
sir.
Everything Sean's lawyer said raised an objection. Were all of his actions irrelevant? The defense didn't have any points of their own, so it seemed like they only wanted to disrupt Sean's attorney. The judge was getting furious.
You weren't present in the clerk's office the afternoon of July 15th, 2021, correct?
Objection, ask the answer.
Sustained. We've had that.
Did the warrant that you did for Mr. Reyes pertain to conduct that occurred on July 15, 2021 in the town clerk's office in the afternoon, sir? Yes or no, if you can.
Rejection.
Nope.
That's the answer.
Okay. We're taking a recess. Counsel in chambers now.
All rise. Court's now in recess.
The judge was furious. He ordered both the lawyers into his chambers, and we can faintly hear how his mood was. The state's attorney's objections were so annoying that the judge had to personally give him an earful. The fact that the judge hasn't put a stop to this waste of taxpayer money speaks volumes about the level of corruption we're looking at here.
While that was compelling to watch, the next killer cop and his attorney were completely taken to the cleaners during his pretrial.
In 2016, a pretrial court was set up to determine Officer Osvaldo Villarreal's qualified immunity after he shot and killed Benny Herrera in 2011. Herrera's family filed a lawsuit leading to this trial.
This is a tragic case, there's no question about that. But Officer Villarreal was required to make a split-second life and death decision.
What required him to do that? It doesn't look to me as though he was the initiator.
The fact that Mr. Herrera, first of all, he had been acting erratically before the shots were fired. From a place of relative safety on the shoulder of the road into the roadway, he was skipping
But if we're
backwards.
talking about Officer Villarreal, how much did he know about the prior behavior?
He saw all of that.
I have to say what you're saying is inconsistent with what I saw on his own camera. That is to say, the point at which he began to get close enough to see anything. Some of that earlier stuff was on the other camera, but not on his.
The tragic incident occurred after Officer Villarreal was called to the scene, where he confronted the deceased. The corrupt cop asked him to take his hands out of his pockets, and just a mere second after that, he shot him twice.
His camera was turned on, but
His camera was turned on well before he got to the scene.
He testified in deposition that he saw Mr. Herrera on the side of the road, and then he saw.
Well, he can testify to what he wants to testify to, but I want to tell you what I saw on his own camera tells me that the early part of this he did not see, could not see. That was his intention, you say?
That was his intention, and that's in his deposition.
Again, I'm relying on what's on the videotape, and now this is in Officer Villarreal's car. I hear him say, take your hand out of your pocket, and I hear the gunshot almost simultaneously.
Exactly.
They cannot be separated by more than a second.
And that's exactly the time period when Officer Villarreal had to make his decision.
Benny Herrera was unarmed and posed no threat to the officer. Shockingly, the officer was also cleared at first.
Before he was asked in deposition, well, what were you going to do when you asked him to take his hand out of his pocket? Well, I was going to put him in a control position. That's what he intended to do.
So he's taking his hand out of his pocket.
Yes.
And as he's obeying the officer's command, he gets shot.
But it's the way that he does it, Your Honor. He didn't just stand still and take his hand calmly out of his pocket. Is he doing this peacefully? Or does he have something in his hand that could be a threat to me and is my life in danger?
Well, right.
He had a fraction of a second to make
Well,
that
don't we
decision.
have to view this in the light most favorable to the plaintiff here? I mean, and so if we do what you just said right now, offer two possibilities. Either
The judges had seen the body cam footage and believed that the officer should at least be tried for this act.
here, Mr. Herrera was arguably complying with Officer Villarreal's order to remove his hand from his pocket at the time that he was shot. How is it that we determine that we should grant qualified immunity?
Because qualified immunity allows for police officers to make mistakes. It allows for the possibility that officers will make mistakes in judgment, and that's exactly what happened here. Officer Villarreal had a choice to make. Do I wait and see whether there's something in the hand that could kill me, or do I shoot? And he made the decision to fire. We know with the benefit of hindsight, obviously, that was wrong.
Is it significant that is it Miali?
If the perpetrator hadn't been an officer, he likely would have been held accountable and labeled a murderer. There are serious flaws in the lawyer's arguments.
He had a better vantage point possibly than Mr. Villarreal.
He actually didn't, for these reasons. Officer Miali was facing, from his point of view, he saw Mr. Herrera's back, not Mr. Herrera's front. So he couldn't see, and he testified in his deposition that he couldn't see Mr. Herrera's hands as they were coming out of his pocket. He also, if he had fired, he would have fired toward an apartment complex. Officer Villarreal fired toward a block wall.
I guess the issue I'm having here is that these are arguments, in my mind, for a jury. That certainly you can lay these out, but we're at a very limited scope here. This is not jury redo. We have to determine based on the facts as alleged by the plaintiff. And right. they're gonna say, no, it was, he simply had his hand in his pocket and these officers were coming up on him really strong. They created the tension, they rose the adrenaline, not him. You have to lay out, take their facts, not the facts as you want. You gotta stick with their facts and explain why under their facts, you win as a matter of law.
I agree, Your Honor.
Every single judge on the panel seemed to be on Herrera's side, and it appeared that the officer was about to lose his qualified immunity shortly.
As long as the historic facts are undisputed, the question of whether or not Officer Villarreal's actions were reasonable is a question of law. It's not a question that you give to a jury, because we don't want juries second-guessing the very, very difficult life and death decisions that officers have to make.
I agree, but at this stage, again, this is not an argument to a jury. For us to even have jurisdiction over this case, those facts, you're saying that as a matter of law, Officer the shooting here was legal.
Yes, it was objectively reasonable. Well, not just those facts. Officer Villarreal knew that Mr. Herrera was a suspect in a domestic violence incident. Okay. He knew that he had a gang affiliation, that he was on parole, that he had a warrant out for his arrest. All of those things factor into
on parole. I don't remember on parole.
On parole, yes, and there was a warrant out for his arrest.
What do we know about what Officer Villarreal knew with respect to whether he was armed?
We know that dispatch told Officer Villarreal and Officer Miali that Mr. Herrera was not known to be armed.
The judges asked the right questions, and the attorney was quickly running out of arguments. Shockingly, she thought this was a reasonable mistake.
Also, the suspect had refused to put up his hands, had threatened the officers, and an officer believed that she saw something in the suspect's hand, saw him move his arm, and was worried he was going to shoot her. But yet we affirmed the denial of qualified immunity in part because the suspect had not brandished a weapon or spoken of a weapon.
I do recall that case, Your Honor.
But that wasn't enough for the attorney, and the judge was about to make her look like even more of a clown.
Domestic violence incident was over.
Yes, and there...
So, I mean, how does that strengthen your case? I mean, that was, if you're arguing that it was an ongoing domestic violence, so...
it wasn't an ongoing domestic violence incident. And it's easy for us to sit in hindsight and say, well, Mr. Herrera didn't have a gun. Mr. Herrera didn't really pose any
I don't think
threat.
anyone here said that one time.
No,
I think what we're focusing on, again, the narrow standard we have to deal with here, and that's what we're dealing with. This is not a jury trial. This is not summary judgment. It's a very limited thing. No one here has raised about the fact he didn't have a gun.
I understand. The trial court did.
The judges then called for the plaintiff's attorney to take the stand and explain why the officer's qualified immunity needs to be removed.
But I think there's no question that he had his hand in his pocket.
Well, and both officers said it looked like he had something heavy in his pocket. And then just before Mr. Vial opened fire, Mr. Herrera rapidly removed his hand and moved quickly, it seemed like, toward the officer's car. Why isn't that enough?
Well, because sticking on the undisputed facts, the officers had no information that any weapon was involved in a crime. They were specifically told he was not known to carry weapons.
The attorney came well prepared and brilliantly answered, completely dismantling the officer's narrative.
Opposing counsel that he's entitled to make a reasonable mistake.
Well, if that was the standard alone, then every single shooting case, the defense would argue that an officer is entitled to a reasonable mistake, and that's the end of the analysis. I think for purposes here, one has to look at the facts supporting the plaintiff's version, and he had nothing in his hands, and he was shot twice and killed. We specifically asked the officers about their training, and they conceded, which is included in the cites in our brief, that deadly force is a last resort, only to be used in the direst of circumstances, only when no other reasonable measures are available.
The defense attorney would once again plead to the judges to withhold the qualified immunity, but things were looking quite tough for the corrupt cop.
The jury does not get to decide qualified immunity?
Qualified immunity is a question of law for the court.
You mean, so depending on, the jury has to decide whether or not there's been a constitutional violation, and at trial the jury cannot say to your officer, you're off the hook because you have qualified immunity? That can't be right.
Predicate facts.
I understand that, but I think I'm arguing on your point. If we send this back, I don't think you want to say qualified immunity is no longer available to you at trial.
Absolutely not.
Well, I think that's what you just said. That's why I'm speaking up.
That was not my intention at all.
Soon, the judges ended the court not before owning the defense attorney one last time.
If everything goes bad for your client, that is to say, if we send it back, if the jury says no qualified immunity, and if the jury comes in with an award of some amount of damages, will your client pay those damages out of his own pocket, or will it be paid by his employer?
It should be 99.9% of the times it's paid by the employer. I don't see why it would be different.
Well, by statute, California statute says it's paid by the employer unless they're punitives.
Yes,
isn't that right?
That was what I was going to say.
So that doesn't say 99%, it says 100.
Well, I was going to say, unless they're punitives. If there were punitive damages, the city would have the option of deciding whether to pay those punitives. My understanding is that...
Shortly after, the judges issued a written statement abolishing the officer's qualified immunity and calling for a trial, alleging that he had used unlawful deadly force. The city soon settled with Herrera's family for $1.4 million, and Officer Villarreal was fired.
Next, watch how this remorseless officer was sentenced to prison for his barbaric crimes.
Defendant Aaron York deemed guilty beyond a reasonable doubt of the offense of manslaughter. Assess his punishment at confinement in the Texas Department of Criminal Justice for 11 years, 10 months, 12 days.
Former Officer Aaron Dean, who fatally shot an innocent woman through her bedroom window, is about to be charged with the heinous murder.
Y'all did fabulous when we did the guilt-innocence verdict, okay? Same rules apply. I don't know what this verdict is. Can't have any emotions, all right? Let's bring him in. Verdict reads, we the jury, having found the defendant Aaron York deemed guilty beyond a reasonable doubt of the offense of manslaughter, assess his punishment at confinement in the Texas Department of Criminal Justice for 11 years, 10 months, 12 days. They do not assess a fine. and it is signed by the presiding juror. You may be seated. Thank you very much.
The killer cop sat across from the judge with no remorse on his face, as if he had no guilt for what he did.
Juror number 1, is this your verdict?
Yes, Your Honor.
Juror number 3, is this your verdict?
Yes, Your Honor.
Juror number 4, is this your verdict?
Yes, Your Honor.
Juror number 6, is this your verdict?
Yes, Your Honor.
Juror number 9, is this your verdict? Juror number 37, is this your verdict?
Yes, Your Honor.
Juror number 38, is this your verdict?
Yes, Your Honor.
Your verdict will be received and filed. Thank you very much. Mr. Gill, Mr. Brissett, is there any legal reason why sentence should not be pronounced?
No legal reason.
Mr. Dean, it's the jury having found you guilty of the offense of manslaughter and assessed this punishment. It's the order of the court you be remanded to the custody of the sheriff, be delivered to the director of the Texas Department of Criminal Justice to serve your sentence as required by law. You will receive credit for all the time that you have served in custody on this case from the date of your original arrest up until today, which would be the date of sentence.
Dean was ultimately convicted of manslaughter instead of murder and was sentenced to 11 years in prison.
If you are indigent and cannot afford a lawyer, I would conduct an indigency hearing to determine if you are indigent. And if you are indigent, I would appoint a lawyer to represent you on appeal and provide you a record of this appeal of this trial at no cost. Is there an allocution? You may be seated. Thank you very much.
The officer is currently in jail, and some people believe the punishment should have been much more. Let me know your comments below. Well, that also brings us to the end of this video. Today we saw corrupt cops swiftly owned and humbled in courtrooms. These judges delivered lessons they'll never forget, setting an example for officers to ensure they never cross the boundaries of the law. If you agree with me, please consider showing your support by liking this video, and also make sure to subscribe to stay informed about future cases like these. Also, if you enjoyed this video, check out the next video here.